case is People versus Samuels. Good morning. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of that time yourself, and you may begin when you're ready.
Thank you, Your Honor. Jacqueline McCann on behalf of Dwight Samuels. I'm joined at council table by co-counsel Aaron Bartels and law student Ashley Munger, who helped us on the brief. I will try to reserve 3 minutes of rebuttal time. As to the court's 2 questions in its MOA order, the first question, we would ask the court to establish or reestablish the rule that an evidentiary hearing is required where a defendant moves to withdraw a plea that was induced in part by a promise of leniency to a relative unless the defendant's entitlement to relief is already apparent on the record. I say reestablish because we believe the court essentially said in Franklin, or did say in Franklin, that this is the type of motion where the trial court is obligated to hold an evidentiary hearing. And that stems all the way back to Ginther in 1973. I have cited Ginther at this point in my career probably hundreds, if not 1,000 times or more, and I didn't remember that Ginther was a plea case, so that this refreshed my memory. There is a good reason for this rule that the court has established, and that is because we want there to be, we want these claims to be fairly evaluated. And if it's not apparent on the record, in terms of these familial family package plea deals, at a minimum, the trial judge needs to know the nature of the relationship, strength of the bond between the defendant and the relative at issue, needs to know some information about the personal characteristics of the defendant, whether they're a vulnerable person, more likely to be coerced by this type of offer, and needs to know something about the relative. In a lot of the cases that this court and the Court of Appeals decided through our history, the relative was sick or had an especially close bond, was a spouse, for instance. The second question, we are asking the court to adopt a totality of the circumstances test as it uses in voluntariness inquiries and other areas of the law, such as confessions, as this court wrote in Stewart, I think, last term. The Court of Appeals below chose the test that some of the federal circuits have chosen, this good faith probable cause test. The very premise of that test is completely faulty. It is that these types of offers with family package plea deals are not particularly problematic. But this type of offer, it's not one of the ordinary carrots and sticks. Family is special. We recognize that in our lives. We recognize that in the law. I think the next case deals with sort of some of the substantive due process issues that go along with family. This court celebrates Adoption Day. This court celebrates Reunification Day. These are things that we know, and the test that they chose ignores that. None of our case law going back from, I think the first case we cited in the brief is from the 60s, even before James, none of them indicate that their focus is on whether or not there's probable cause, whether or not that aspect of the offer was illusory, as I would say. They all focus on the nature of the relationship between the defendant and the relative. So Michigan should stick with what Michigan has always done.
So Ms. McCann, can you help me say that we agree with you and that the Court of Appeals was incorrect in saying that the probable cause, the single factor is the only relevant consideration in these type of pleas, and that the standard should be what it is for voluntariness generally, right? The totality of the circumstances. Are you advocating that that we need to create a sort of a distinct procedure for package plea deals where the trial court has to explicitly consider these certain factors and make a finding of voluntariness before accepting the plea? Or are you saying the existing procedures are fine, but that we should emphasize that, you know, the existence of a plea deal or a family plea deal is highly relevant, and these are the things that need to be considered in this specific instance of voluntariness? Does it have to happen first, or is it just sort of a general category of voluntary?
Well, a couple points, Your Honor. The court's order, and because this is a motion for plea withdrawal, obviously we're taking sort of the retrospective look. Could the court change the court rule in sort of a prospective manner? I don't think that this is quite like some other areas of the law where you've done that recently. It's not a discrete term where you can say you've got to tell people about consecutive sentences. You've got to tell people about the habitual offender maximum. You've got to tell people about LEM. Those have been the last few changes the court has made in the court rule. I do think there's a few things in the mechanics that would help. I don't think it's a good idea for the relatives to be in the same courtroom when they're entering the pleas and interacting with each other as was done here. The court could probably ask some more probative questions. I think some of the out-of-state case law has some suggestions. But I do think to a large extent it is sort of beyond making sure the court knows, because I think even in this case, it's actually Dwight who first sort of brings up the aspect of it being tie-barred, and then his attorney says, oh yes, Judge, this is tie-barred, and I've made that clear to him. So absent him asking that question, I don't know that it would have been stated to the court. So it should be stated to the court, so the court can make some sort of inquiry about, you know, are you doing this because you want to, or are you doing this for your family member? But those sorts of things, I think the court would be better off to publish or to seek input on a court rule, you know, as that process through the rules.
Why is the whole concept of these package deal plea bargains, why is it suspect?
Because, Your Honor, I think particularly for the reasons pointed out in the amicus brief from the American Psychological Association.
Look, I get it. The family that commits crimes together stays together. I get all that. But the question is that the prosecution has a big interest in efficiency, the court system, and not, you know, if they're going to offer plea bargains, they don't have to offer a plea bargain. There's no constitutional right to a plea offer. And if there's going to be a co-defendant case, to say that we're going to offer the deal, but it's a package both people have to accept, or if we're going to have to go to trial, we'll just try both defendants. What's wrong with that? As a concept, in theory.
In concept, Your Honor, we're not asking the court to say that you can't have package plea deals amongst family or amongst
you're saying
strangers.
They're inherently suspect so that if someone says anything at all, they get an immediate evidentiary hearing. So that puts them in a category of highly suspect, right?
Well, Your Honor, I think we cited a case from the U.S. Supreme Court, Birkendyer, Birken something, that said, you know, when it's a package plea deal, that's going to impact the defendant's risk analysis, and that might have an impact on due process.
It might put some added pressure on a defendant to accept a plea. I guess the question is why is that unfairly coercive when they're thinking about the picture more broadly and other people who are impacted by the very criminal activity that they were involved in? I mean, there's co-defendant cases all the time. Just because they choose to commit a crime with a family member, the court system can't just ignore that. I mean, it's all part and parcel of what's been presented, packaged up and presented to the court system for us to deal with, right?
Yes, Your Honor, and I would take issue that your question assumes that they are guilty, and part of the danger of this familial package plea deal is...
If I said that,
yeah.
I'm not assuming anybody's guilty, but I was a trial judge. I'm sitting here listening to you. I'm thinking about a particular case where there's co-defendant brothers in a very serious case where somebody was killed. And I sort of wish there was a package plea offer, because the one defendant didn't make a very intelligent decision. He was young. his brother, his older brother, took the plea bargain, and the other defendant was convicted of a life offense, and that's that life without parole, and he was offered a much more reasonable, my memory, goes back a long ways, but maybe it was 15 years or something like that, and he wasn't making very, intelligent decisions, but, and so maybe if there was some familiar pressure, he might be a little happier today. In other words, this is kind of fortuitous how it works out, right? You wouldn't be here if you're only here that the facts work out a certain way, right? I mean,
So there is a difference between whether it's an intelligent plea, a knowing plea, and a good idea versus whether it is a voluntary plea.
No, I get it.
And what we don't want, especially in addition to not wanting to induce involuntary
You want people to make
pleas.
good decisions, I think. I mean, I don't mean to, I'm probably using all the technical words wrong from our court rule, but you want people to to know what the terms of the deal are, to get good legal advice, and to make a good, sound decision.
And to make a voluntary decision.
I just don't know why thinking about how it'll impact a family member automatically means we should be very skeptical.
But
of
again,
whether that helps them to make a good, sound decision. Maybe it helps them in some cases.
Can a package deal for family ever, can it ever be voluntary?
yes, we're not asking you for to say that per se, these are all involuntary. That's not how we've done it since the 60s. But because it's not per se, we do need to look behind it at the facts as, like, there could be if the defendant's being offered manslaughter down from murder and his third cousin is also as a result going to get his misdemeanor dismissed, that's probably not an involuntary plea. But Dwight, who is a twin, who has some intellectual and emotional problems, and when he says to the judge, "This isn't fair, I want to go to trial," and the judge says, "Well, that's not really my problem," it's Dwayne's attorney who jumps in and says, "Hey, your brother, he wants this deal," and then Dwight says, "Okay, I'll go ahead." That is coercion. That is overbearing his will. He wouldn't have entered the plea but for that.
By the other defense attorney? I mean,
Sorry?
by another defense attorney is what I'm hearing, not by the prosecution.
Yes, Your Honor, but it's my contention that because it is the familial package plea deal, the government is relying on the other family member to apply that pressure and the circumstances of the other family member to apply that pressure. So it is governmental pressure.
So can you have a familial relationship where it's the same crime that they're being tried for? Can that ever be voluntary? In the situation here, what could have made this a voluntary decision?
It would have been voluntary if Dwight hadn't said, "I don't want to do this, I want to go to trial," at the plea hearing. If they hadn't complained, yes, it's voluntary if this is what they want to do. But if they're only doing it because they want to go to trial, but their sick relative, who they depended on all their life, can't get the deal without them taking it, then that overbears their will, and that is the government doing that.
And that's,
So-
go ahead.
Yeah, so I'm trying to understand. So is it the underlying facts that we then look at, or do they have to affirmatively state something? Because if they hadn't said that, and I mean, we could develop any sort of fact situation where, take brother and put him in an even worse situation, and the pressure is there. I mean, I'm trying to figure out what line you're asking us to draw, just even in this case, and then I'm trying to think of all the other cases.
The line I'm asking you to draw is that when the defendant, again, because we are looking retrospectively, and we can deal with prospective with the court rule, but retrospectively, when the defendant moves to withdraw his plea, we look at the totality of the circumstances, including the familial package plea deal aspect. There's other aspects here. There's the inadequate factual basis. There's them telling the court they've got defenses or mitigation. You can look at that as outside of the familial aspect or within the familial aspect. But just like in the confession cases, you look at the totality, and if it turns out on evaluating those factors that this really wasn't a big deal, this really wasn't an important factor in the defendant's decision, this really didn't overbear his will, then you deny the motion. But if you look at it and it's Dwight,
Isn't your rule based on how much affection one person has for another? So why would it be limited just to the family setting? Why, if I had a really good friend that I cared a lot about, grew up with, and we're co-defendants because we went out and committed some crimes, why doesn't your rule apply there?
well,
'Cause
some
I would
states,
feel really bad if, I made the other person, same idea, right? So
some
you're
states
basically
do
attacking,
extend it.
you're attacking all packages.
I am
plea
not.
bargains.
Some
No, but
states
the-
do extend it to all of them.
Well, the very
Um,
next person that we're gonna see come into court's gonna say that, right? So we should be ready for that.
I think you can easily say that family is different. Family is different in all kinds of areas of the law.
Geez, that doesn't seem to be the trend of modern society. Seems to be less and less important.
Can I
family.
ask you one question before you're done, just to confirm? If we adopt the Ibarra factors, and I think I heard you say this, I'm curious of how you would summarize what you think is the overall standard for a court determining whether or not it was voluntary. And I think you said is based on the totality of these circumstances, if the court can be convinced that the defendant's will was not overcome.
Yes, was
Then it
not
was
overcome by accepting it just for the family member. And in issue 3, we set out a number of factors from Ibarra, suggested some additional ones. Ibarra itself, I think, was not a family package plea deal. It was an anybody package plea deal. So we've tried to modify them somewhat to the focus on the family.
So those factors, but your overall standard is overcoming the will of the defendant to accept it.
The same as in any other voluntariness test.
Is it sufficient enough for the defense attorney and the judge to ask those pointed, specific questions?
It's not if the defendant
If
comes
the
back
questions
later.
are asked by
Yes.
the defense attorney and by the judge, you know what you're getting into. You're not making this decision just because the offer was for you and a family member. You're making this decision. Those questions are asked and they're answered in the affirmative.
Then I think it would be very difficult for the defendant to win a motion for plea withdrawal. Is somebody ever going to bring one? Yeah, I'm sure somebody might bring one, but absent them being able to show this person was acting, there's really a FBI agent back at home with a gun to my wife's head, it'd have to be extraordinary because that is going to make it very difficult to overcome. The regular plea colloquy, as we've argued in our brief, does not waive it.
Thank you.
But just before you go, your position is the fact of a package deal alone is enough, right? So the person doesn't have to say there were any outside of the record promises, threats, or inducements made or pressure brought to bear. In your case, it was all done on the record. All you need is the defendant to say, yeah, geez, I really felt pressured by this and I wouldn't have done it, and you win. I mean, why do we even need an evidentiary hearing? Shouldn't we just,
No,
do it
Your
by
Honor.
affidavit, shouldn't we?
If you look at this plea hearing, it's 40 pages long. This is not a garden variety plea hearing. This is
But it's all on the record, right? There's no complaint here or allegation that something was done, pressure was brought to bear outside of the court hearing. Is
one
there?
aspect of our claim is that it is possible that pressure was brought to bear because the family members are acting all crazy behind them.
But how
It
can
appears
there-
they're trying to communicate with
If it's
them.
your client's making the claim, wouldn't he be the one to know whether pressure was brought to bear? I mean, how could you say
Well,
it's
yes, Your
possible
Honor.
that it was brought to bear, but he doesn't know it?
Well, you denied our motion to give you an offer of proof. So I'm
Well,
trying to
that's-
stay relatively limited to the record.
Okay, so you would go beyond the record,
Yes, if you give me an evidentiary hearing, I have lots of stuff that I can go beyond the record.
okay?
Thank you.
Thank you.
Good morning, Chief Justice, Your Honors, and may it please the Court. Margaret Gillis Ayalp from the Wayne County Prosecutor's Office on behalf of the plaintiff appellee, the people of the state of Michigan. First, in seeking an evidentiary hearing to examine his claim of coercion, defendant points only to the so-called offer of leniency. But that offer was entirely of record and accepted by him and lawful. He does not claim that something not of record coerced him. There is nothing to explore at an evidentiary hearing, therefore. Regarding the second issue, defendant implies that the Court of Appeals was an outlier in adopting the probable cause test. To the contrary, the Court of Appeals reasonably turned to federal precedent in addressing this issue of first impression. And every federal circuit which has examined this issue, 10 or more of them, has adopted the probable cause equals good faith rule, and with good reason. The rule ensures that the plea was not premised on an illusory bargain which could have rendered it involuntary. Further, the plea offer was never presented as involving an offer of leniency to a relative. It was a package plea offer to two co-defendants who were going to be tried jointly. It had nothing to do with them being related. The people were not going to try one and give lenient treatment to another. The benefit of the bargain to the people was not having to go to trial. And they weren't going to allow one to plead and then testify for the defense at the brother's trial, take the blame with nothing to lose. Also, the record belies defendant's claim of coercion and shows that his real complaint has always been that he did not receive the 11-year minimum sentence that his brother did. This was confirmed at the motion and sentencing hearing, where the transcript shows that the very first reason defense counsel gave for why his client wants to withdraw his plea was that defendant was, quote, dissatisfied with the negotiated agreement, and then specified the sentence agreement. Coercion, that was on page 5. Coercion wasn't mentioned until page 13, after there had been a recess. And notably, there were 2 weeks between the plea and sentencing hearings. There was no written motion to withdraw a plea filed by either party, nor was there a request to order the transcript on an expedited basis in order to bolster their claim of coercion.
Counsel, can you help me? So we know the general rule for assessing voluntariness of a confession is the totality of the circumstances. Why should there be a special rule in familial plea package deals that considers only one of the circumstances, the probable cause issue? Why do we have a special rule that is less restrictive than in general when we're looking at voluntariness of any other plea?
Certainly. So the people do not contend that in accepting a plea, the court cannot look at the particular circumstances of that case. Of course, it's required to. And certainly there are lots of factors that go into assessing whether a plea is voluntary. The court does have the requirements that it must adhere to in 6.302 and the case law, as Sister Counsel mentioned, adding new requirements in regarding omissions of plea terms that affect the sentence. But we're looking at, the court posed a question of how do we determine voluntariness when an offer of leniency to a relative is involved. In that specific narrow question, we're saying, absent aggravating circumstances, you look to, was the offer made in good faith? Was it a legitimate plea term to offer? And if it was, then the defendant is not any more unduly coerced or pressured than he is with any plea term that he has to examine. Self-imposed pressure and stress in wanting to choose the right choice between two very difficult decisions, whether to accept a plea or go to trial and take your chances, that does not equal coercion. We'd also like to address the defense reliance on People v. Franklin. And with due respect to Justice Markman and the majority in that case, I would point to pages 109 and 110 of Franklin, where the court clearly conflated the requirements of certain court rules to have a motion hearing, to have a hearing when a motion is filed. Yes, there are circumstances in court rules that require that. 7.208B, MCR 2.119E and F. However, they do not require an evidentiary hearing. Franklin simply misstates the law and what the court rules require. Franklin does not stand for the proposition that every motion gets an evidentiary hearing, or even that those court rules say that. Franklin needs to be reread and tempered, the people would suggest, because it simply misstates when a hearing is required. It's also important to distinguish here that the joint package deal here may have involved two relatives, but that's not why the plea offer was made. It was made out of expediency, and also it benefits the defendants to have lesser charges and lighter sentences. But there are some offers of leniency that where the offer is that the charges against the relative, usually a wife, will be dismissed. So we do want to distinguish that some package deals do involve offer of leniencies, and some offers of leniency do not involve a package deal. It's one pleads guilty to keep the other one from being charged when the charges are valid and would have been valid. And we want to note that regarding the claim of coercion, the plea transcript taken as a whole and read as a whole shows that the coercion claim is not genuinely made. The defendant was comparing his math. He said 18 years for a plea versus 25 years. If I go to trial, doesn't make any difference to me. Then his math was corrected both by his counsel and the court. Well, wait a minute. Your minimum would be 18 versus 30 years. Immediately after that statement, when his math was corrected on what minimum sentence he would face if he went to trial, 30 years, he said, yes, I want to plead. And right then, the court needed to address another case. It took a 34-minute recess. And in that 34 minutes, defendant could have changed his mind. He could have come back on the record and equivocated. Instead, he came back on the record and expressly and without hesitation accepted the plea terms. Yes, Your Honor. No. Yes, Your Honor. He was unequivocal in moving forward on his plea. And certainly it's required that any evidentiary hearing must be supported by an offer of proof of what facts are needed to explore at the hearing. There has to be a need for further factual development, which there is not here. So to conclude, I'm happy to stand for any questions. To conclude, to grant any type of relief here under the present facts would open the door to unsupported claims of coercion, would burden the trial court with unwarranted evidentiary hearings, and would threaten to undermine the confidence in the plea proceedings and the sworn testimony taken there. The plea
What if
proceeding.
defendant had done a little bit more at the plea hearing and had said more than what he already did, and said, I'm only doing this because this is what my brother wants, and specifically gave reasons of why he was doing it?
Well, if everything's of record and the court, we think the court here was meticulous in trying to hear what the defendants were saying, respond to their arguments, and I think had the court responded to that and ensured, perhaps, I would like to think the court may have taken a further recess, another recess, or examined the defendant again. I don't think that simple statement by itself, if nothing else is shown, would have rendered the plea involuntary if it was followed by the colloquy that did follow. The defense refers to the colloquy as a script. It's only a script if the defendant is not being honest. The colloquy means something. The court is genuinely asking the questions to probe the voluntariness of the defendant's plea. His sworn statements in response must mean something. And so if that colloquy occurred and the defendant was examined, we think that would still be fine. That did not happen here, as Your Honor noted. But so we ask the court to not undermine the confidence in the plea process. It would have a chilling effect on plea bargaining, which is vital to the criminal justice system, and which ultimately benefits not just the courts and the prosecutor's office, but the defendant as well. Thank you.
Thank you. Any more questions? Thank you. The case will be submitted.